The fight over magazine bans just took another major turn, and we are now potentially heading towards an unusual situation at the United States Supreme Court, because there will soon be two cases asking for the Supreme Court to resolve the exact same constitutional question, but coming from opposite sides of a direct circuit split. On one side, we have the Duncan versus Bonta case, where the Ninth Circuit upheld California's magazine ban. And on the other side, we have the ANGRPC versus Platkin case, where the en banc panel in the Third Circuit struck down New Jersey's similar ban on magazines that hold more than 10 rounds, and that circuit court expressly disagreed with what the Ninth Circuit prior said. And now New Jersey is preparing to take that ruling directly to the Supreme Court. That could completely change how the Supreme Court handles Duncan in their upcoming term and what they want to do with magazine bans. So let's break down what is now going on in this critical issue and these two cases. Now, before we jump into this video, if you like this type of content and you want to ensure that you get videos going forward, make sure to subscribe to the channel and also turn on all notifications. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. One of the really cool things that they do is they do not have a ton of exclusions. For example, relevant to this video, if you have maybe a magazine that holds more than 10 rounds and you're in one of these states, or if you use a type of prohibited item that the state does not like and you use that in a valid self-defense situation, AOR will not drop your coverage. They do not have those type of exclusions. So that is just one of the many benefits that they have. They're always expanding upon their benefits to give you as much as possible as a member. So if you're interested in that type of coverage, check them out using the links down below. And right now, if you use my code ARMSCHOLAR, you can save additional money on your sign-up fee. Now, for those not aware, in July, the en banc Third Circuit panel issued its decision in the ANGRPC case and also the Cheeseman case, which were consolidated, one dealing with magazine bans and the other dealing with the state's AR-15 bans. Now, by a 10-5 vote, the court held that New Jersey's prohibition on magazines capable of holding more than 10 rounds does in fact violate the Second Amendment. Now, in that ruling, the Third Circuit directly confronted the Ninth Circuit's reasoning that was prior used in the Duncan case, also dealing with a similar issue, but simply just California's ban on magazines that hold more than 10 rounds. The Ninth Circuit in the Duncan case concluded that magazines are essentially accessories, or what they called accoutrements, and attempted to distinguish between magazines holding 10 rounds and magazines holding more than 10 rounds. Now, the Third Circuit went in the opposite direction. The Third Circuit concluded that magazines facilitate the operation of firearms and therefore fall within the Second Amendment's protection of arms. It also rejected the idea that constitutional protections somehow disappear once a magazine holds more than 10 rounds. Most importantly, that means that we now have two en banc federal courts of appeals reaching exactly opposite conclusions on essentially the same constitutional question, revolving around state bans on magazines that hold more than 10 rounds. So that is a textbook situation where the Supreme Court review becomes extraordinarily important and almost always happens. And this is where things get really interesting, because Duncan is already sitting in front of the Supreme Court. The Duncan plaintiffs filed their petition asking for the Supreme Court to review the Ninth Circuit's ruling, but the case appeared to potentially be sitting in kind of a procedural limbo, maybe on hold, while the Supreme Court considers the major semi-automatic rifle ban cases, the Vermontes case and the Grants versus Higgins case, which they will review this upcoming term and issue a ruling on also this term. But then the ANGRPC case happened after that. On August 3rd, the Duncan plaintiffs also filed a supplemental brief telling the Supreme Court that the circumstances have now fundamentally changed. There was no longer merely disagreement over how Bruin should apply on magazine bans. There was now a direct en banc circuit court split on this very issue. The Duncan plaintiffs essentially told the court there is no longer a reason to wait on this issue. The justices now have the Ninth Circuit saying that these restrictions are constitutional, and the Third Circuit saying the exact opposite. And now the ANGRPC case will head to the Supreme Court as well. The Third Circuit recently stayed its mandate in the ANGRPC case while New Jersey seeks Supreme Court review. That means that the Third Circuit's decision will remain blocked, at least for now, while New Jersey takes this case to the Supreme Court and asks for review. Because of the ruling and this stay, New Jersey is forced essentially to have to take this case to the Supreme Court and bring up this current circuit split. Typically, And, procedurally, the deadline to file for Supreme Court review runs for about 90 days after the Third Circuit's, issuing of the judgment, which happened on July 17th. And that puts New Jersey's current deadline for the petition to be filed to the Supreme Court for October 15th. Also, I do want to note that New Jersey could seek an extension from Justice Alito if they wanted, and maybe Justice Alito in the court would grant that extension to further push this out if they wanted to punt on this issue. But as of right now, October 15th is the deadline where New Jersey needs to file that petition. So unless something changes, the ANGRPC case itself is now heading towards the Supreme Court. And that creates a very fascinating procedural situation. So think about what the Supreme Court could soon have sitting in front of it in regards to these cases. In Duncan, the gun rights plaintiffs are asking for the Supreme Court to review a judgment upholding a magazine ban out of California. In the ANGRPC case, New Jersey will be asking for the Supreme Court to review a judgment striking down their state ban on magazines. Both rulings came from en banc courts, came from full circuit courts, and they both came to different conclusions. That gives the Supreme Court several different ways that it could actually resolve the situation. The Supreme Court could potentially grant both cases, coordinate their consolidation and review similar to what it did in Vermontes and Grant versus Higgins, or the Supreme Court could continue holding one or both of these cases while the court decides the semi-automatic rifle bans this upcoming term. But based on the ruling in the ANGRPC case, it makes it simply impossible for the Supreme Court to just outright ignore this, so they're going to have to do something in regards to magazine bans and these two cases. Of course, there is still another layer to all of this. The Supreme Court has already granted review in these major cases dealing with rifle bans. Those cases could establish important Second Amendment principles involving common use and what qualifies as an arm or, an accessory or something like that, and essentially how courts are supposed to conduct the historical analysis required under Heller and Bruin when it comes to these types of bans. California and New Jersey therefore have an obvious argument that they're likely going to try to use to stall these cases. They can tell the Supreme Court, don't decide the magazine ban cases just yet, decide the rifle cases first, and then send these cases back down to the lower courts to reconsider whether these magazine bans violate this new ruling. And that is one of their ways to not only stall this case, but maybe give the Third Circuit and the Ninth Circuit another opportunity to rule in their favor. And that is probably what the states want the most, because that would avoid an immediate nationwide Supreme Court ruling that would directly address magazine bans for everyone nationwide. But in response to this, the gun rights plaintiffs do have a powerful response and argument. The circuit split currently exists right now. Millions of Americans are living under fundamentally different interpretations of the Second Amendment, depending entirely upon which federal circuit court you live in and what state you're in. So there are now several dates and developments we need to watch for. First, Duncan remains pending before the Supreme Court. And second, New Jersey currently has until October 15th to file its petition for a writ of cert in that ANGRPC case. And unless it obtains an extension, that is the deadline that we're currently facing. But the fact remains that the ANGRPC case has dramatically increased the pressure on the Supreme Court to eventually provide a definitive answer on state magazine bans and these types of restrictions. And that is what makes New Jersey's upcoming cert petition so important. So between now and October, the ANGRPC case and Duncan cases are something that we're going to be watching very closely. But if you want to continue to get updates on these, if you want to continue to get news as it develops, make sure you like, comment, subscribe, and turn on all notifications so you get those videos when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.